Bismillahirrahmanirrahim. Assalamualaikum warahmatullahi wabarakatuh to my Muslim student. Hi everyone. Okay, today I would like to continue with our next topic. Next topic we are going to learn about law of tort. This is supposed to be under trespass. We have three topics under law of tort. So the first one I will focus on trespass. Sorry class, this was supposed to be lecture number 14. Okay, so before I go for the detail, the brief contents for this trespass, we have three categories on the right hand side. Number one, we have trespass to person. Number two, we have trespass to good, where some people call this one as interference with the good. Where under the word, under this category, there are three subcategory. We have conversion, and we also have detinue. Okay, you have seen the word conversion before in the introductory, so this one falls under interference with the good. And the third one, we have trespass to land. Right. In order to the plaintiffs to make sure that they are able to win the case or able to show that they are establishment for the trespass, basically we have to show that they have a positive act. A is actually a person. Number two, A has direct act of the defendant, and the action is actionable per se. That is the term referring to not necessarily to show the damages. Okay, not necessarily to show the damage. Sorry, you don't have to show the damage in order to claim the action under trespass. That is the term referring to actionable per se. Okay, now I would like to go to the first one. The first one, we have trespass to person. So I go to the first category known as assault. So what is assault? It is actually an attempt or a threat. Okay, if you see the word threat, this is part of the category for assault. This is actually they apply the unlawful force to the person for another, whereby that another person is put in fear or violence. The keyword is when you feel fear because of the defendant's action, or when the plaintiff feel reasonable, scared, or you are in violence, you feel so worried because someone has threatened you. That is referring to the assault. Striking at another with a stick of the fist, even though the party missed his aim, that will constitute to an assault, especially when they have intention. Okay, throwing a bottle, but this throwing a bottle is not to the defendant. Throwing a bottle to show that he actually in angry. He put the other person in the reasonable scared force that will constitute to an assault. But then we cannot simply say that the assault happened until we see the element to establish assault. Okay, so basically assault is the thought of acting intentionally and voluntarily causing the reasonable apprehension. The word reasonable apprehension also referring to the feeling of immediate harmful, the feeling of scared, the feeling of feeling violence or offensive contact. Okay, because it required the intention to be proven by the plaintiff, it is considered as intentional thought. Okay, this is in contrast with the law of tort under negligence, because negligence not required intention to be the evidence for establishment of the tort. It is important to note that actual ability to carry out the reasonable apprehension is not necessary, where an assault can take place with a toy gun. For example, let's say you show a knife to another person, showing a gun to another person so that another person feel so scared, even though they didn't kill you, but maybe they shoot on someone else, throwing a bottle on somewhere else, but because he showed that he showed something that make you feel reasonable apprehension, that may constitute to an assault. Okay, in order for you to explain whether assault is actually established, you can use the word establish. Okay, in order to the person or the plaintiff to show that assault established, there are elements that you have to fulfill. Okay, so the first element, we have mental state of defendant. Number two, we have to consider the effect of the plaintiff. This is actually the title. we will look at how and what is the meaning of mental state of the mental state of the defendant, capability of carry out the threat, and also the bodily movement. Okay, so what about the words? Can the words constitute to an assault even though there is no action? Okay, so basically when you see after this, as long as you have fulfilled mental state, effect on the plaintiff, capability of carry out the threat, the words may constitute to an assault. Okay, because as long as you can show that you are in the reasonable apprehension. Sometimes we see something, at the same time you show the gun, okay, or you see something and sometimes you show a knife, so that will cause reasonable apprehension to the other party. Now let's look at the first element under the item under assault. Number one is mental state. When you see the law mention about mental state, it is always to see the capacity of the person who carry out the threat, whether the person is in sound mind or in unsound mind, okay, or whether the person has intention or not having intention. Okay, in this term, we are referring to the intention of the party, because once you have intention, means you know the implication of your act. When he know the implication of that, but they still carry out, that means you have that defendant has the intention to do so. The defendant told the plaintiff, if I were not a Sistan, I will not take those words from you. That is the example as stated in Tuberville versus Savage. In this case, you can see the court mentioned that this word is negative to the element of intention, because it is not actually show that that defendant has giving the intention to do something bad to the plaintiff. Okay, and this is also the element that give the negative element of the first item in establishment of the assault on the defendant's part to injure the plaintiff. And therefore, because of this negative element about the intention, the court did not grant the plaintiff to claim this issue under assault. Okay, now let's look at the effect on the plaintiff. The other way, before we mention that established amount of the assault is happened, we have to show that the plaintiff feel reasonable apprehension. For example, let's say you feel scared, you cannot sleep for one week, because you always feel like, okay, someone will kill me, someone will show something bad to me. So that is the feeling of reasonable apprehension. But of course, when you bring this matter to the court, you need to show the evidence, like you already went and see the doctor because you cannot sleep, you take the sleep pill, for example, because of that feeling. Reasonable apprehension is determined by the objective test as follows. Would a reasonable man, means if you are in his position, faced with the same situation that the plaintiff was in, feel apprehensive that a force will be inflicted upon him. That means they are tests that normally the court will ask the plaintiff. If you are, or they will ask normally a panel or jury, or they will ask if you are a reasonable man, if you are a normal man, if you are in the position of the plaintiff, do you feel that reasonable apprehension? If the answer is yes, then the element of the effect on the plaintiff is fulfilled. Okay, so in order to establish the assault, we also have to consider the word force. That means it is some form of the violent contact that will put a reasonable man to be in the reasonable fear, reasonable scared, reasonable violence. They feel that. Okay, and then number three, we have to consider the capability of carry out the threat, because sometimes there is no contact to be proven under assault. But if, let's say, someone did not stop this defendant, there are possibility that the defendant may carry out the threat. Okay, so this requirement is measured through the eyes of the reasonable plaintiff. They are tests to follow that, for example, would a reasonable man who is in the plaintiff position feel reasonable fear that a threat is immediate force upon him? This is another keyword for you to explain if you want to show that the other party, or you have to show that the plaintiff has feel the reasonable or immediate force because of the defendant action. In other words, would the reasonable man believe that defendant will realize his trade? Okay, if someone did not stop you, maybe they will cause the damage to the plaintiff. Now, I would like to look at this example. The defendant threatened to hit the plaintiff. See the word threaten, okay? And he advanced him with the clenched fist upon the plaintiff. He did not do anything yet. So this is the first fact. He was top party. Just before he could reach the plaintiff. He was stopped by another party. Sorry, he was stopped by another party. Let's say this is the defendant. This is the defendant. Defendant has threatened to hit the plaintiff. This is the plaintiff. Okay. So let's say the defendant is not stopped by the third party. For example, there are possibility that the defendant will hit the plaintiff. The court held that the assault was established as he here is referring to the defendant. He was capable of carrying out his trade if he was not stopped by the third party in a few seconds before he hit the plaintiff. In this case, there are possibility that the plaintiff is not being fight by the third party, by the defendant, but because it was stopped by the third party. So in this scenario, maybe the third party is the person who has suffered the damage. That are the scenario to show that it is very important to show that if you did not stop that person, they are capability. Capability means they are possibility to carry out the threat by the defendant. Okay, even though the assault involved no contact, it is often said that the bodily movement is necessary. Sometimes because of your eyes, because of when you show the fist to someone, bodily movement to show that you show to someone. Okay, body movement means a positive act in the circumstances indicating that defendant will carry out his trade. This is something like make the people feel violence because of your own movement or your gesticulation. That gesticulation is the bodily movement. Okay, so body movement per se will not be sufficient. The movement must such that the correspondent with a probable infliction or show unwanted force to the plaintiff. Okay, there are certain scenario body movement is sufficient. There are certain scenario body movement is not sufficient. So we have to look at scenario and scenario. Okay, now this is the thinking that I would like to carry out earlier as well. Can a word constitute to an assault? What do you think? Basically, in general principle, mere words cannot constitute an assault. But if the words or the mere words is together with the gesture, gesticulation, bodily movement, the proof that to prove that the other person has or feeling threatened because of the words, that will constitute to an assault. Okay, let's say you simply say, or if you didn't do this, I will kill you. So that is very clear words to mention that the other person has feel threatened. Okay, they mention words, but they didn't do any bodily movement. But let's say the words really mean something, I will kill you. But there is no body movement. There is no reasonable movement of force. But then, because of the word, sometimes they will make another person feel reasonable apprehension, feel so scared. So that will also constitute to an assault, even though fundamentally the mere words cannot constitute to an assault. Okay, tone of voice, facial expression, gesticulation are the item that need to be considered by the court in order to evaluate the establishment of an assault. Okay, so you can see here, this is with the gesticulation. This one with, the evidence that you are holding the knife, but didn't say anything. So that also will give the consideration by the court to consider whether an assault is actually established. That is the first element under trespass to person. Okay, now let's go to the second category under trespass to person. This is known as battery. Okay, this is not the battery like what we used to. The battery in this trespass to person or in the eye of the law means applying force, okay, however slight, to the person, to another, hostility or against him. But this one basically must be done without the plaintiff consent. Okay, the charge of battery is usually combined with the assault, namely assault and battery. Okay, the charge here are referring to the action to bring the defendant to the court for hearing. When you charge someone, when you sue someone, it is normally combined with the assault and battery altogether. As distinguished from the assault, battery require an actual act. If you look at assault, there is no contact. It is not touching each other. But in order to establish battery, it required an actual contact. You have to touch and so on. Okay, look at example. Throwing water at him. Okay, if throwing water at him with his consent, no issue. But throwing the water at him without the plaintiff consent, there will be the issue. Okay, number two, holding him by the arm, also without his consent. Spitting on his face, definitely. Removing a chair under the him. This is not only battery, but it is actually beyond that. Or throwing a squib at him, definitely considered as a battery. This is simple example of the battery. Okay, now we look at the general explanation on battery. Merely touching a person is not considered a battery. For example, let's say you want to call someone, then you touch his or her shoulder. Hi sis, and so on. So merely touching, when you go to the supermarket, you call but there is no response. When you just touch a little bit to engage his attention, this is not considered a battery. Okay, in action for trespass to the person, it is essential to prove that the defendant acted intentionally or negligently. Both are considered. And then the other one is volunti non fit injuria. This is the term under the Latin concept to show the consent of the person is a notable defense in his type of action. For example, they say the plaintiff claim from the defendant, okay, but the defendant can prove that actually the plaintiff has the consent to do so. Okay, has the consent to do so. So that is actually the strong defense on behalf of the defendant to show that the plaintiff has consent. Why suddenly you claim from me? Okay, this is one of the example where normally you have been asked by the doctor, by the hospital to sign, to allow the doctor to carry out maybe operation or any procedure to the patient where the patient has agreed or had given the consent. Basically that is very good defense if something happened to the doctor, to him. So if he would like to claim from the doctor will show the proof, okay, you have consent that I already carry out this and that. Okay, this is under battery. Now look at this simple example. A runs over B with his car. So this is the example of battery. The battery is actionable per se. That means the claim for the tort may be succeed without the proof of damage. Okay. Now we look at what are the basic elements to the establishment of the battery. Okay, this is considered as intentional tort. So basically, the first issue that you have to consider is mental state of defendant. Again, this is intention. Number two, the defendant's act under his control. This one is under his control. It is not being forced by someone else, and it is also not negligence by another person. And number three, you have to show evidence that the contact happened. And number four, you have to show the proof that this is done without the plaintiff consent. Okay, so as what I told you before, number one, the plaintiff has to show that the defendant has intention to do so. The defendant has applied the force with the intention, and basically this is referring to the Okay, so although the general rule is that the intention relates to the direct act by the defendant, the doctrine to transfer the issue of the intent widen to the scope of meaning of intention when he know the risk of having this action. He know the risk of spitting to the other people face. He know the action if he hit someone. Okay, thereby extending the possible liability of the defendant. Okay, so number 2, you can see the example. You can see the example of the case under Scott versus Shipyard. A lighted squib was thrown by the shipyard or the defendant into an open market. A picked it up and threw it upon B, who then picked it up and threw it away. You can see this scenario. Maybe he would like to just take this one as the fun, but the squib hit the plaintiff, whereupon it burst into the flame. Okay, because maybe he would like to make it fun, but at the end hit the plaintiff. The court held the defendant was liable for the tort of trespass, although his initial gesture did not directly affect the plaintiff, but it's already affected the plaintiff because he has intention to do so. He has intention to throw it away, but maybe accidentally hit the plaintiff. Okay, he know what is the implication if he threw it away to another person. According to the court, A and B reacted for their own safety, and they did not have the required intention to commit the act. But because that action is already show that he know the implication of his action, so there are possibility that he has to be liable. Okay, so in this case, the court held the defendant was liable. Okay, now let's move to the next one. Number 2, we also have to prove that defendant act must be done voluntarily. That means it is not forced by someone. The defendant act is because of defendant itself. If you look at this example, Gibbon versus Pepper, the defendant was riding a horse when someone hit the horse from behind, causing the horse to bolt. It is something like what happened in the car accident, for example. Okay, the horse collided with the plaintiff, and the action against the defendant, the court found that the defendant is not liable because the incident of the horse bolting and colliding was outside his control. But this is actually different from some of the cases. Some of the current case we may consider to refer to this one because you can see the word outside his control. But if you are not be able to claim under battery, in this case there are possibility that you can claim under negligence because of your action. But then it is not easily established because as far as you know that action is because of your act, not because of something else, not because of the animal, not because of the surrounding area, basically or generally you cannot claim under battery because the element is the defendant must, because the defendant must act to show that he is done voluntarily. It is not because of someone else, because of the horse. Okay, the next one, the element that you have to establish is the term contact. Okay, there will be no battery if no contact or application on the plaintiff body. Okay, the word force is used in the technical sense where no violence is necessary.